Welcome to the Near Memo, a weekly conversation about search, social, and commerce. What happened, why it matters, and the implications for local.
Cool. All right. It's over to
On
me.
to you. That's it.
So
Now we're into a much more detailed discussion,
Right. So
which
there was
may
a
not
very,
be...
well, I think it's of interest to everybody in the marketing
For
world.
sure.
But
Absolutely.
It takes a long time to get to the punchline, for which I apologize, but I'm known for that style. So bear with me. Obscure Supreme Court case early June that looked at called Van Buren, in which a cop was charged with accessing licensing data inappropriately, and they used the Computer Fraud and Abuse Act. Now, the problem with the Computer Fraud and Abuse Act is terms like unauthorized access or exceeds unauthorized access or exceeds authorized access have never been defined. So this is really the first case for the Supreme Court. And they threw out the FBI set up a sting to get this cop through a gangster to look up license plate information or licensing information for a prostitute, whatever. And he had access to this information. He just was using it improperly. And they declared that that case would be thrown out, or any charges based on the Computer Fraud Abuse Act were thrown out. So as a result of that, though, LinkedIn and Microsoft requested that the Supreme Court throw out the Ninth Court's decision that allowed HiQ to scrape LinkedIn's data because they want to retry that. So essentially, in 2019, the Ninth Court determined that it was okay to scrape public data because you were already authorized to see it. So there was no unauthorized access. There wasn't any,
and no distinction between a human being and a computer accessing public information.
That's correct. But the question that this raised is whether LinkedIn telling HiQ, sending them a cease and desist order, and attempting to create barriers to the bots and having a terms of service is enough to create unauthorized access. So it's a slightly different area of the Computer Fraud and Abuse Act that was looked at. Now, the reason this is important, at least in the marketing world, is that virtually at least in the review space particularly, there isn't a review company in the world that's helping businesses understand reviews that isn't doing scraping either themselves or buying scraped data from one of the data providers like ASG, my previous employer, or somebody else. And virtually every report that we looked at, that you look at, ranking and all these other things are all based on scraped data. And LinkedIn is Microsoft, and they're looking to put a stake in the ground that says that it's inappropriate to scrape data when it's against terms of service, and they've attempted to put technical barriers in place, and they've sent a cease and desist order. Now, if it requires all three things, it means that scraping might still happen, but at a lower level. But it puts at risk many aspects of the marketing ecosystem. And I think that the HiQ LinkedIn case is one that is worth following, that I've been following for 2 years, because there's never been a decision whether it's legal to scrape public data or not. And so everybody does it. Google basically doesn't discourage it. If your volume gets too high with Google, they'll put in place some IP blocks, and they're pretty good at it, from what I understand. If you get too much volume, but they tolerate it. I don't know, who else uses scraping? Who else gets scraped? Obviously, all the review sites, but what other marketing platforms need scraping besides ranking and reviews?
Ads get scraped all the time, right? SEMrush has an entire ecosystem product built around scraping Google Ads and estimating costs and all of that stuff. So, it feels like agreed. Like there's it has the potential for major implications for a lot of Martech and ad tech tools. I think my question, not that I expect you to answer it, but a question I have for the universe is the extent to which some of these ongoing antitrust cases will impact how much data these big tech companies are required to share with competitors in order to maintain a healthy ecosystem.
It would be ironic if Yelp were required to share public review data
Right, exactly. And at what level, is revenue the sort of threshold that kicks in when companies are required to share or not? Is every company required to share any publicly accessible data with any other company? I do think that it's a viable way for the DOJ to ensure a more healthy product ecosystem, is to force some of these larger tech companies to share more of the data, or allow users essentially to share that data across multiple products. So,
although you run this risk, much like that happened in Europe, where all the big companies are thus favored. For example, let's take Yelp, which currently requires an agreement that costs at least $25,000 a month to get access to copyright information, i.e. a review that they don't own. And as part of that agreement, you have to agree not to solicit reviews at Google or Facebook or Yelp for you have to pay them $25,000 to agree
That's
to
right.
that.
I forgot the policeman of the internet mindset.
Right. Yeah. So let's say that becomes the only way that they're made to make this publicly available, but they can charge for it. Then all of a sudden, smaller and startup companies can't access that public information that they don't own, that Yelp doesn't own the copyright to, and it could have egregious outcomes if implemented improperly in terms of limiting the ability for creative uses of data that should be part and parcel of what the internet's all about. But we'll see.
Agreed. So we'll have to see how that case turns out. And who do you subscribe to for these legal updates? It feels like this is a regular recurring topic here on the Near Memo.
One is Eric Goldman, but he didn't talk about this one yet. And then I subscribe to the FTC feed, which is very interesting. And they just laid down yesterday a whole new set of sort of put stakes in the ground around enforcement and antitrust that been a long time coming, that will again allow them to look at issues of competitive harm that they haven't been able to look at before. And I can't remember where this one popped up, but
I'm sure Goldman will cover this at some point when it gets retried.
Yes.
So
if you're looking for just general internet law, Eric Goldman's the place to go. And then the FTC is very good because clearly they're much more activist this term, and it'll be very interesting to watch them over the next couple of years because the Democrats have a 3-2 majority. All three Democrats are very progressive and assertive, consumer, competitive, antitrust in favor of broader antitrust interpretation. So the legal area is going to heat up and it's going to affect us all. So I think it's worth paying attention to.
Absolutely. And not that was a particularly negative story, but we do like to end on a positive note, which
despite my internal inclinations to just sort of not, but
right.
I'll go with it.
So we do want to wish Greg a really happy 4th of July weekend, and wish all of you guys a happy 4th of July weekend. Happy Canada Day, I think, to our Canadian listeners, which is a little bit more of a last week story, but just seems like there's a lot more to celebrate this year. And we hope that you guys all have a really happy weekend spent with friends, family, maybe even get outdoors if the weather is okay in your neck of the woods. So
that's what
I will end on that happy note.
Friends, family, and bike riding. So we're and it looks like good weather. So
yeah.
All right.
Great. Well, we hope it's nice wherever you are, and have a terrific weekend. And Greg will be back we'll have the full Three Amigo squad back next Friday.
Thanks for joining us.
Thanks for joining David, Mike, and Greg. To stay on top of the latest developments in local, subscribe to our newsletter at nearmedia.co. We'll see you next week.